All right, I am here with David Azizi from the law offices of David Azizi, and today we're going to talk about a little bit of modern technology and how it has changed the way we live. And I think everyone is at fault for doing this. When you walk into a grocery store or a Best Buy or a Walmart or a Costco, sometimes you get a text or you get a phone call and you look down and you continue to walk. I think this is very common in the world today. I think you'll see it anytime you go into the grocery store. So while looking down and walking, you're not necessarily looking at what's going on in front of you, and maybe there's a wet spot on the floor, maybe there's a box here that causes a trip and fall, or the wet spot causes a slip and fall. So David, if you're looking down at your phone or you're texting, is there still a way that as a lawyer you see the premises at fault for negligence of causing this slip and fall accident?
Well, here in California, the law, the way it is comparative fault. So if there's any basis to say that the party who's bringing the lawsuit has some comparative fault, then what you have to do is you have to look at the facts and details of the case. You mentioned a box. If this box is in plain sight, it's something that this pedestrian or this customer would have realized and would have noticed had it not been for themselves looking at their phone, and they tripped and fell. It all depends on the jury. You know, jurors make their decisions. Sometimes you would think, yeah, jurors are going to go ahead and find this person at fault. Sometimes they may not. Sometimes they may turn around and say the business is at fault for allowing such a box to exist in the middle of the walkway because it's a tripping hazard. Sometimes they may come back and say, no, it's the fault of the customer for not paying attention to what's in front of them. So in that kind of case scenario, it's questionable. You know, the jury can go either way. There's other scenarios where, for example, if it's a clear liquid substance that's not readily noticeable, and it's on a surface, for example, white floor surface, white clear liquid substance, well, the argument in that case could be made that even if the person was not looking at their phone and weren't momentarily, their attention was taken away because of looking at a text or texting something and walking, that even if they were looking in front of them, this particular clear substance would not have been noticeable because it's clear, it's on the floor, the person would have slipped and fell. And the argument is most people who go to a supermarket are there with the, should I say, the premise or understanding that the store, as a responsible store owner, has gone ahead and made sure that the floor is free and clear of any slippery substance. So, for example, like you said, if you get a text, you are in the assumption that, okay, I'm in a store, I don't have to worry about any particular slippery substance or trip hazard being on the floor, so I can take a moment and say, and under the impression of safety, typing something quickly and then moving on. So, but to answer your question, it's all based on comparative fault, and it's all based on the evidence. It's a case-by-case situation, circumstance. There's a lot of details that go into it, and ultimately it gets presented to jury, and the jury decides as to, yes, comparatively at fault, and how much the store is at fault, or how much the store is not at fault, or the plaintiff is not at fault at all. It's all the store's responsibility.
Absolutely. And if you have had a slip and fall accident or a trip and fall accident in the state of California, please contact the law offices of David Azizi. You will see the phone number both above in the YouTube video as well as below in the info. Thank you for your time, David.
All right, thank you.